Welcome to the appendix, where we read the primary sources of the past so the present can be better understood. Today's primary source, Chisholm versus Georgia, 1793. This is probably the most important of the early cases which came before the Supreme Court, and in the decision of the court can be found a foreshadowing of the nationalism enunciated by Marshall a decade later. The case of Chisholm versus Georgia arose out of the efforts of Chisholm and other citizens of South Carolina and executors of the estate of an English creditor to secure compensation from Georgia for property confiscated during the Revolution. The Constitution of the United States provided, Article 3, Section 2, that the judicial power of the United States should extend to controversies between states and between a state and the citizens of another state. Under this provision, could a citizen sue a state in the federal courts? That this clause authorized such suits against states was denied by Hamilton in the Federalist and by Madison in the debates in the Virginia ratifying convention. It is not, said Madison, in the power of individuals to call any state into court. The only operation it could have is that if a state should wish to bring a suit against a citizen, it must be brought before the federal court. Yet, in this case, the Supreme Court upheld the right of Chisholm to sue Georgia in the Supreme Court. Georgia refused to appear before the court, denied the validity of the judgment, and threatened to punish by death any official who should attempt to execute the decree of the court. Other states also protested, and shortly after the decision, an amendment was introduced which deprived the federal courts of jurisdiction in cases against one of the states by citizens of another state. This, the 11th Amendment, was ratified January 8, 1798. Wilson J. This is a case of uncommon magnitude. One of the parties to it is a state, certainly respectable, claiming to be sovereign. The question to be determined is whether this state, so respectable and whose claim soars so high, is amenable to the jurisdiction of the Supreme Court of the United States. This question, important in itself, will depend on others, more important still, and may perhaps be ultimately resolved into one, nor less radical than this. Do the people of the United States form a nation? To the Constitution of the United States, the term sovereignty is totally unknown. There is but one place where it could have been used with propriety, but even in that place it would not perhaps have comported with the delicacy of those who ordained and established that Constitution. They might have announced themselves sovereign people of the United States, but serenely conscious of the fact they avoided the ostentatious declaration. 3. I am, thirdly and chiefly, to examine the important question now before us by the Constitution of the United States and the legitimate result of that valuable instrument. Under this view, the question is naturally subdivided into two others. 1. Could the Constitution of the United States vest a jurisdiction over the state of Georgia? 2. Has the Constitution vested such jurisdiction in this court? I have already remarked that in this practice, and even in the science of politics, there has been frequently a strong current against the natural order of things, and an inconsiderate or uninterested disposition to sacrifice the ends to the means. This remark deserves a more particular illustration. Even in almost every nation which has been denominated free, the state has assumed a supercilious preeminence above the people who have formed it, hence the haughty notions of state independence, state sovereignty, and state supremacy. In the United States and in the several states which compose the Union, we go not so far, but still we go one step further than we ought to go in this unnatural and inverted order of things. The states rather than the people, for whose sakes the states exist, are frequently the objects which attract and arrest our principal attention. This, I believe, has produced much of the confusion and perplexity which have appeared in several proceedings and several publications on state politics, and on the politics, too, of the United States. Sentiments and expressions of this inaccurate kind prevail in our common, even in our convivial language. A state, I cheerfully admit, is the noblest work of man, but man himself, free and honest, is, I speak as to this world, the noblest work of God. With the strictest propriety, therefore, classical and political, our national scene opens with the most magnificent object which the nation could present. The people of the United States are the first personages introduced. Who were these people? They were the citizens of the 13 states, each of which had a separate constitution and government by Articles of Confederation. To that purpose of public strength and felicity, that confederacy was totally inadequate. A requisition on the several states terminated its legislative authority. Executive or judicial authority it had none. In order, therefore, to form a more perfect union, to establish justice, to ensure domestic tranquility, to provide for the common defense, and to secure the blessings of liberty, those people, among whom were the people of Georgia, ordained and established the present Constitution. But that Constitution, legislative power is vested, executive power is vested, judicial power is vested. The question now opens fairly to our view. Could the people of those states, among whom were those of Georgia, bind those states, and Georgia among the others, by the legislative, executive, and judicial power so vested? If these principles on which I have founded myself are just and true, the question must unavoidably receive an affirmative answer. If those states were the work of those people, and that I may apply the case closely, the people of Georgia in particular could alter as they pleased their former work to any degree, they could diminish as well as enlarge it. Any or all of the former state powers they could extinguish or transfer. The inference which necessarily results in that the Constitution ordained and established by those people, and still closely to apply the case in particular by the people of Georgia, could vest jurisdiction or judicial power over those states, and over the state of Georgia in particular. The next question under this head is, has the Constitution done so? Whoever considers in a combined and comprehensive view the great texture of the Constitution will be satisfied that the people of the United States intended to form themselves into a nation for national purposes. They instituted for such purposes a national government, complete in all its parts, with powers legislative, executive, and judiciary, and in all those powers extending over the whole nation. It is congruous that, with regard to such purposes, any person, natural or artificial, should be permitted to claim successfully an entire exemption from the jurisdiction of the national government. Would not such claims, crowned with success, be repugnant to our very existence as a nation? When so many trains of deduction, coming from different quarters, converge and unite at last in the same point, we may safely conclude, as a legitimate result of this Constitution, that the state of Georgia is amenable to the jurisdiction of this court. But, in my opinion, this doctrine rests not upon the legitimate result of fair and conclusive deduction from the Constitution. It is confirmed beyond all doubt by the direct and explicit declaration of the Constitution itself. Quote, "The judicial power of the United States shall extend to controversies between two states." Unquote. Can the most consummate degree of professional ingenuity devise a mode by which this, quote, controversy between two states, unquote, can be brought before a court of law, and yet neither of those states be a defendant? Quote, the judicial power United States shall extend to controversies between a state and citizens of another state, unquote. Could the strictest legal language described with more precise accuracy the cause now depending before the tribunal? From all, the combined inference is that the action lies. Chief Justice Jay and Justices Blair and Cushing concurred. Justice Iredell dissented. Thank you for joining us for our primary source today on the appendix. We will see you in the stacks.